Today we start talking about tort law. We have to begin by defining what tort law is. Well, a tort is a wrong or an injury to another other than breach of contract. Two notions serve as a basis for all torts: wrongs and compensation. Tort law recognizes that some acts are wrong because they cause injuries to others. Most crimes involve torts, but not all torts are crimes. Now I want to stop and remind you something. When we first talked about the classification of crimes in the beginning of the semester, we stated that there were two broad areas of law in the United States. You have criminal law, which is public law, and civil law, which is private law. Now, anything that is not criminal law is civil law. Tort law is a really big part of that. Now, when we talked about criminal law, one of the things that we said was when a crime is committed, it's committed against society as a whole, not just the victim. And because it's committed against society as a whole, it's the state that prosecutes the defendant, not the plaintiff. It's the state that brings the lawsuit. And if the defendant is found guilty, the defendant could go to jail, could be fined, or even be killed if the crime was serious enough. In a criminal lawsuit, the victim is really just the star witness and doesn't get anything except for satisfaction when the lawsuit is over. Well, tort law addresses that, and that's why most crimes involve torts. At the conclusion of a criminal proceeding, the victim, the injured party, can sue the defendant in civil court to recover damages under a tort claim. Now, tort law is private law. A tort action is a civil action in which one person brings a personal suit against another. That's what I just described. Now, what are the purposes of tort law? First purpose is to compensate an injured person, to make that person whole. Generally speaking, money is enough. The second purpose is to prevent private retaliation by injured parties. Think about this. If we didn't have laws in place set up so you could sue someone to recover damages for injuries they caused you, what would most people do? You take the law into your own hand. You crash my car, I'm gonna crash your car. You beat me up, I'm gonna beat you up. That would be taking the law into your own hands. That would be retaliating against the person that hurt you. Would not be that effective. The third thing tort law does is reinforce the vision of a just society. Now, the law clearly states there's certain things that people are not allowed to do you. They're not allowed to injure you or damage your property. When this occurs, the state allows you to sue them, right? That's called justice. Finally, the purpose of tort law is to deter future wrongs. Right? And by deter, it's really just to make people mindful of what they're doing and let them know that there are consequences for their actions. And I'm going to be honest with you. Losing all your money, losing all your assets, paying someone back is something that most people don't want to do. So that has a tendency to make people careful. Now, there are three basic types of torts. The first type is an intentional tort. Now, I want you to look at that first word, intentional. Intentional means on purpose. Intentional torts occur when a defendant takes an action intending to bring consequences, knowing they're likely to result. Intentional torts occur when the defendant takes actions intending certain consequences, or knowing they're likely to result. If I decide to drop a flower pot out of the window, do I know that it's likely to hit the ground? The answer would be yes. Right now, if I drop the flower pot out of the window and that flower pot hit you in the head, that would be an intentional tort. I didn't necessarily know I was going to hit you in the head, but I knew it was going to hit the ground. I knew it was going to go down, so I'm responsible. The second type of torts are unintentional torts, also called negligence. Negligence occurs when a defendant acts in some way that subjects others to an unreasonable risk of harm. The defendant takes an action that subjects others to an unreasonable risk of harm. Now, the key here is unreasonable. Unreasonable. It has to be something that is beyond the pale, something that a normal person would never consider doing. Third type of tort is a strict liability tort. Strict liability torts occur when the defendant takes an action that is inherently dangerous and cannot be undertaken safely. Fireworks come to mind for me, right? When people are doing fireworks displays, right, they're engaging in strict liability tort-like action. If anybody is injured as a result of the fireworks displays, they'd be liable, even if they took every precaution they could think of. Why? Because fireworks are inherently dangerous. Now, what are the damages available in tort cases? There are three. The first are compensatory damages. Take a look at the base word. The base word is compensate. Compensatory damages are designed to compensate the victim for all the harm caused by the person who committed the tort. Once again, compensatory damages are designed to compensate the victim for all of the harm caused by the person who committed the tort. Second type of damages are nominal damages. Nominal means small. Nominal damages are a minimal amount that signifies the defendant's behavior was wrongful, but no harm was caused. Third type of damages are punitive damages. Punitive means punishment. Punitive damages are damages that punish the defendant and seek to deter others from the same conduct in the future. Let's talk about intentional torts for a second. Intentional torts involved acts that were intended to bring about the consequences that are the basis of the tort. Now, once again, I've highlighted the word intended because this means that the act was on purpose. With intentional torts, the tortfeasor, this is the person committing the tort, must intend to commit an act, the consequences of which interfere with another person's personal or business interest in a way not permitted by law. Once again, I've highlighted intend. What does this mean? That means it's on purpose. It's on purpose. Now, major point to remember, the intention here is based on the intention to do the act, not the intention to cause the harm. Once again, the intention is based on the intention to do the act, not the intention to cause the harm. The consequences of the act are irrelevant. The only thing that matters is the desire to commit the act when determining liability for an intentional tort. So what does this mean? Well, let's say you're running to the elevator and you see one of your buddies and you take a quick detour over to them and to say hello. You smack them on the back. You just pat them on the back. When you pat them on the back, you hit them a little bit harder than you intended, and you knock them down. When they fall, they break their leg. Here's the thing. You are responsible for that broken leg. It does not matter that you didn't intend to break the leg. All that matters is you intended to pat them on the back. You're responsible for everything that flows from that initial action. Now, intentional torts can be committed against both persons and property. Now, obviously, when a tort is committed against property, it is in fact committed against the person that owns the property. But the reason why you have this distinction is because when you commit a tort against a person, that means you actually injure that person's physical or mental body. When you commit a tort against property, that means that you damage that person's property, whether it's damaging their house, their car, their TV, their clothes, right? That's what property is. The property can't sue you, but the harm was directed towards the property. Now, the intentional torts against persons include assault, battery, false imprisonment, intentional infliction of emotional distress, defamation, invasion of privacy, and fraudulent misrepresentation. We're going to start with one of my favorites. Assault is an intentional act that creates in another a reasonable apprehension or fear of harmful immediate physical contact. Right? As we stated, assault is the threat of contact. There is no contact. Now, one thing that assault does require that battery does not is awareness, awareness, awareness. Battery simply requires the contact. Assault requires that you be aware of the impending contact. Think about this. You can have one cause of action from which two people can have legitimate claims, one claiming assault and the other claiming battery. You're standing outside and this guy across the street picks up a rock to throw it at you. You see the rock coming. You move out of the way. The person who was standing behind you, whose head was turned in the opposite direction, did not see the rock coming. They're hit in the head. Both of you can sue the thrower. You, because you saw the rock coming, could sue the thrower for assault. Why? When you saw that rock coming, did that create in you a reasonable apprehension of fear of immediate harmful offensive contact? I'd have to say yes. The other person who was not paying attention at all wasn't scared of getting hit by the rock because they never saw the rock. But what happened? They got hit in the head by the rock. So what was that? That was a harmful or offensive physical contact. Now, once again, I want to go back. Intentional torts. What was the intent that was necessary? The intent that was necessary was the intent to throw the rock. Didn't matter who the rock hit to establish liability. All that mattered was that the tortfeasor, the person that committed the tort, intended to throw the rock. Now, yes, it is possible for one person to have two claims from one cause of action. You could sue for assault and battery if you saw the rock coming and it scared you and you weren't able to move out of the way and it hit you, right? So you could sue for assault and battery, but the burdens of proof, the two, are different, and that's why you always have to separate the two. Now, battery, once again, is an intentional, harmful, or offensive physical contact. So, are there any reasons why you might have to batter somebody? The answer is definitely yes. So let's talk about the defenses to battery. Defense number one is permission, 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 aka consent. When a person consents to an act that damages him or her, there's generally no liability for the damage. Now, I know that sounds kind of wild until you think about it. Not that sensational. All of you probably played sports. You play football, you play basketball, even soccer, a girls' game. Well, when you play these contact sports, what happens? When you're playing football, people physically are trying to knock you down. When you get knocked down, it hurts. When you play basketball, particularly when you're up under the boards, you got elbows and body checks all over the place. They also hurt. You're playing soccer, you got several people going for the same ball. Sometimes somebody misses the ball and they kick you. Does it hurt? The answer is yes. Can you have broken limbs? Can you have severe damage? The answer once again is yes. But here's the thing. Did you consent to play? The answer is yes. And given your consent to play, you gave everybody permission to play with you. So if they hit you while they were playing, it's on you, not them. Next, we have defense. First among the defenses is self-defense. An individual who's defending his life or physical well-being can claim self-defense. Now, there are a couple of rules that go along with self-defense. First, you can only use reasonable force to defend yourself. Deadly force can only be used when you truly believe that you're in danger of death or serious bodily injury. Right? That's the only time deadly force can be used. What's reasonable force? Reasonable force is the amount of force that is necessary to remove the threat. Now, reasonable and equal are not the same, because reasonable force is whatever amount of force is necessary to remove the threat. Now, a lot of times when people hear reasonable force, they think equal force, but that's not true. A whole lot of factors come into play. Size matters, gender matters, age matters, right, in determining what is reasonable to defend yourself. Right, so if you're a big man and you slap a small woman, if she slaps you back, would that be reasonable to defend yourself? The answer is probably no. For her, picking up a chair would likely be reasonable. Right? However, if you're a big man and you get punched by another big man, picking up a chair to hit the man back would probably be unreasonable. Right? So these factors come into play. Now, rule number two, caveat number two, is once the threat is over, you must stop. A lot of people are trained in martial arts, whether it's karate, kung fu, BJJ, Muay Thai. And when you train, you're usually taught to do things in combinations, not one punch, one block, but it's usually a series of techniques that you're taught. And you drill these things over and over and over again until you get what they call muscle memory. So when you do one move, it flows automatically into the next move. Well, this training can get you in trouble. Why? Let's say I threw a punch at you. You blocked the punch. You punched me in the chin. You knocked me out. But because of your MMA training, you followed me to the ground and you initiated a ground and pound. You hit me 15 times after I was knocked out. That was excessive force. That was not reasonable. You would have no claim of self-defense, and I could sue you for assault, even if I was the initiator. Next, we have defense of others. Defense of others. An individual can act in a reasonable manner to protect others who are in real or apparent danger. Now, the same rules apply when you're defending someone else that applied when you were defending yourself. You can only use reasonable force, and you must stop once the threat is over. Now, one of the things that I want you to pay attention to is real or apparent danger. Well, real danger is obvious. Somebody's actually being beat up or being hurt or being robbed or whatever. Apparent danger, right? If it appears to you reasonably that this person's in danger, right? Defense of others would be a defense even if you made a mistake, right? You see two people who look like they're fighting, right? And let's say one's a man, one's a woman, and you decide that you have to go defend the woman, right? So you grab the guy, put him in a chokehold, slam him down. They were playing, they weren't fighting, but to you it looked real. That would be sufficient for you to claim defense of others as your defense, right, for committing battery. Finally, we have defense of property. Defense of property. In defending property, reasonable force may be used in an attempt to remove intruders from one's home, although force that is likely to cause death or serious injury can never be used just to defend property. Can never be used just to defend property. Now, if somebody breaks into your house and you reasonably believe that they're there to hurt you, to kill you, or someone in the house, then you could use deadly force, right? But you cannot shoot trespassers. You cannot stab trespassers, right? So maybe I put up a bad slide because I got these knights standing out here with spears and swords, right? But they're just a visual deterrent, right? Unless somebody was coming at them with weapons, they could not use those weapons to defend that castle. But I think it looks cool. All right. The next tort, number 3, is false imprisonment. False imprisonment is the intentional confinement or restraint of another person without justification. Now, I've highlighted without justification. Why? If you are justified in restraining a person, it's not false imprisonment. All right, let's say there's a party at my house and you come over. And of course, there's some alcohol and stuff, and you've had a whole bunch of drinks. Let's say you've had about 15 drinks and you're walking around wobbling all over the place, and you decide it's time to go home. Well, you drove there, and I say, well, okay, you can go home. Why don't you take a cab, right? We will, get your car to you tomorrow. You can come back tomorrow and pick it up. And because you're drunk, you say, I ain't taking a cab anywhere. I'm going to drive my damn car. Where are my keys? Now I'm looking at you wobbling and slurring all over the place. I say, oh, your keys are in the bedroom. When you go into the bedroom to get your keys, I lock the door. Is that false imprisonment? The answer is no. Why? Because I was justified in confining you to protect you from yourself and to protect others from you because of your inebriated state. Now let's say you came over to my house for a party, and it was one of these parties where we had no alcohol. We played cards, we watched games, we played videos. And when the party was over, you said, it's time to go home. Where are my keys? I said, they're down in the basement. And when you go to the basement, I lock the door so I can play with you later. That would be false imprisonment. I was not justified in locking you in the basement to play with you later. Now, what's our defense? Actually, before we go to defense, I almost forgot this. How can you accomplish the confinement? Through use of physical barriers, locking you in a room, physical restraints, handcuffing you, taping you to a chair, or threats of physical force. If you get up out of that chair, I will kill you. All of that is sufficient to accomplish the confinement. Now, false imprisonment has one real big defense, and it's probable cause or the merchant's defense. Probable cause or the merchant's defense. In most states, a merchant is justified in delaying a suspected shoplifter if the merchant has probable cause, a reason to believe that the detained party is guilty of shoplifting. Now, I believe that almost everybody in this class, at one time or another, has been detained for shoplifting. Now, I know everybody's saying, no, that never happened to me, but think about this. Have you ever gone to a mall and you shopped in a whole bunch of stores, and as you start to get tired, you're not really paying attention to the cashier, and a cashier in one store might forget to take a sensor off. So you go into another store, and when you're leaving that store, right, the alarm at the door goes off, and security comes over and says, do you mind if I see what's in the bag? You probably just forgot to take a sensor off, right? Guess what? They've just delayed you because they suspect you of shoplifting. You haven't done anything, so normally they conduct the delay in a reasonable manner, right? They just say, okay, can I see? They look in the bag. Oh, here's the sensor. They take the sensor off. No harm, no foul. And that brings me to my next point. The delay must be conducted in a reasonable manner with regard to time and manner. Right now, time is always going to be relative, right? Because time depends wholly on the situation, right? For example, if you see a woman walking into your store, and when she comes into your store, she's a size 2, and when she gets ready to leave, she's a size 22, meaning she's been putting things in her coat pocket. Can you detain her? The answer is yes. Now, here's the thing. You can put her in a room, and you can hold her in that room for a reasonable time period. Now, if you're male and you detain her, can you search her? The answer is no. You have to get someone who's qualified to conduct the search, like a female security person or a female police officer. So you could hold that person until such time as someone who has the skill set and the qualifications necessary to conduct the search is there, right? Now, could you hold somebody overnight? The answer is no. That would be unreasonable, right? If you see somebody that you suspect of shoplifting, could you strip search them and leave them chained to a desk naked? No, that would be unreasonable. It has to be conducted in a reasonable manner. Intentional infliction of emotional distress is an act that amounts to extreme and outrageous conduct resulting in severe emotional distress to another. Physical symptoms are required. And when we say physical symptoms are required, this means that a medical expert must state that this person had this mental breakdown, this mental distress, because of the action. So it can't be anything that's normal, like you have a boyfriend or girlfriend, and every day you look at him, dummy, 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 dummy. You so dumb. I don't know I'm with you because you so dumb. And the person has a nervous breakdown because you call him dummy, dummy, dummy every day for 6 months. Is that extreme or outrageous? The answer is no. The courts wouldn't find that to be extreme or outrageous because calling somebody dummy, dummy is not that bad. But let's say, let me tell you the story of my grandfather. My grandfather's from Texas, and he had a neighbor, and the neighbor had this little foo-foo dog named Percy. And the little foo-foo dog was on a chain in the neighbor's yard, which was right next to my grandfather's house. And every day when my grandfather was walking up his walkway to go to the door, this little dog would run over to him, barking at him. And he'd almost get to my grandfather, and the chain would pull him up short. The dog would fly back. So my grandfather said, if this dog bites me, I'm going to kill it. So grandfather lives next to this guy a couple years, nothing happens. One day, he's walking up his walkway. Dog comes barking at him, running like he does every day, like he's done for years. Grandfather didn't pay that much attention. This day, the dog is not in the chain. What happens? Dog bites my grandfather. My grandfather reaches down, grabs the dog, pulls out his knife, slits the dog's throat. Takes the dog in the house, dresses the dog, cuts the dog in little pieces, and puts the dog in stew. Makes a stew out of the dog. His neighbors run around saying, oh my God, have you seen Percy? I've lost Percy. Where could Percy be? And my grandfather says, really? Let's come in the house. Let's talk about it. Let me see if I can help you figure out how to save Percy. As they sit there talking, my grandfather looks at him. He says, are you hungry? Have you had anything to eat today? He says, no, I haven't had time. He said, well, I made some stew. Why don't you have some stew? So my grandfather feeds him a bowl of this stew. The guy finishes. He says, oh my God, what are we going to do about Percy? He said, we're not going to do anything because you just ate Percy. Dog bit me, so I cooked it and you ate it. The man has a nervous breakdown. Spends a month in the hospital. And when he gets out, you know what he does? He sued my grandfather for intentional infliction of emotional distress. Now, I'm going to ask you a question. Do you think that killing somebody's dog and cooking them will be extreme and outrageous? The answer is probably not. However, feeding them to a person that you know is emotionally attached to the person, to the dog, will be extreme and outrageous, right? So my grandfather lost that, had to pay quite a bit of money. Defamation is our next tort. Defamation is a wrongful hurting of another's good reputation through false statements. Please remember the word false. Now, in order for a false statement to be considered defamation, there's a publication requirement. This simply means that the statement must be communicated to a third party orally or in writing. So that means that if I say something you do directly that's false, I'll walk up to you and I say, you know what? You're nothing but a dirty, stinking liar, and I know you rob little kids coming home from church on Sunday. If I say that to you, if it's an A and B conversation, it is not defamation. Now, if I go and tell somebody else, I say, Bob is a dirty, stinking thief, and he robs little kids on Sunday when they're coming home from Sunday school. If it is false, it's now been published, so now I'm liable for defamation. Right? So the statement must always be made to a third party. Now, here's the thing that a lot of people don't realize. Anyone who repeats or republishes a defamatory statement is liable. Doesn't matter that you weren't the first to say it. All that matters is that you repeat it. You can be sued. You can be sued. Now, there are two forms of defamation. Slander is oral defamation, whereas libel is written defamation. Now, there's one more form of defamation called slander per se. As a general rule, to prove liability, the plaintiff must suffer some harm or injury as a direct result of the defamatory statement. There are, however, some specific defamatory statements that by their nature are so harmful that no proof of injury is required. The following statements all fall into this category and are deemed slander per se. When one falsely states that another has 1. a loathsome disease like AIDS, 2. has committed improprieties while engaging in a trade or profession. Let's say you're an accountant and I start telling people that you've been embezzling your clients' funds. What happens to your accounting practice? You probably go out of business because who's going to take the services of somebody who steals their money? 3, a person has been imprisoned or committed a serious crime. If I run around telling people you've been in jail, you're a convicted felon, could you lose your job? Yes. Or 3, that an unmarried woman has been unchaste. All right, this is somewhat antiquated, but it still applies because reputation. Once you destroy somebody's reputation, it's really hard for them to get it back. Now, just in case you're wondering, slander per se means slander in of itself. That's what per se means, in of itself. Now, as with all, there are defenses to defamation, and the real big one is the truth. The truth is an absolute defense for defamation. And you remember I asked you to remember that word in the very beginning? False. If a statement is true, it cannot be false. The truth is the truth. The truth is not a false statement. So the truth is an absolute defense. Now there is a caveat, and the caveat applies to public figures. The caveat applies to public figures. If a statement is made about a public figure, made in a public medium, and related to a matter of general public interest, a public figure must prove that the statement was made with actual malice. Actual malice means that the party making the defamatory statement made it with knowledge of its falsity or reckless disregard for the truth. They knew they were lying, or they didn't care. They knew they were lying, or they didn't care. I think about Tom Cruise. Many, many years ago, when he was married to that Australian woman whose name I cannot remember, but she was in Aquaman. She played Aquaman's mother. Name might come back to me. They were married for a while. Nicole Kidman. Told you I would come back. They were married for a while. And she never got pregnant, and they started adopting children. So the story came out in the British tabloids saying that the reason why they were adopting children is because Tom Cruise was infertile. Well, Tom Cruise was furious, but because he was a public figure, an actor who made his living in the public eye, he had to prove actual malice. And when they did some research when he was pursuing this lawsuit, they discovered that the newspaper that ran the story did not exercise any due diligence. They did not check to see whether the facts were true, right? They just heard somebody say he was infertile, so they ran with the story. He sued, and I believe he won something in the neighborhood of $10 million. You contrast this from Eddie Murphy, right? Many, many years ago when he was driving down Hollywood Boulevard and he was arrested with a transsexual prostitute in the car with him. All right, so all these stories started running. Eddie Murphy has sex with transvestites. Eddie Murphy attempted to bring a lawsuit. What was the result? All the newspapers, all the TV news shows started running around interviewing transvestites to see if any one of them had ever had an encounter with Eddie Murphy. And you know what happened, right? A lot of people said yes. Eddie Murphy had to drop the lawsuit. Why? He could not prove actual malice. Why? Because the newspapers, the folks reporting the stories, exercised due diligence and they attempted to corroborate the facts to make sure that what they were reporting was true. Oh my goodness, Sofia Vergara came in last. Well, we got to fix that. Privilege is another defense. Under certain circumstances, a statement is privileged. Privilege is absolute if the statement is made pursuant to a judicial or legislative proceeding. Now, one of the reasons why privilege is going to be absolute when it's made pursuant to a judicial or legislative proceeding is because, you think about a trial. What do you need to prove your case in a trial? You need witnesses, right? So if someone's on the witness stand, they have to be comfortable in stating what they believe is true, even if it turns out not to be true, without being feared of being sued afterwards, right? So if you say something pursuant to a trial, even if the statement is defamatory, you cannot be sued. Why? Your privilege is absolute. Now, with regard to legislative proceedings, this is when the House is in session, when the Senate's in session, when the state assembly is in session, right? Why is it privileged? Because they write the laws and they want to be able to say what they want to say against each other. But here's the key. The statements are only privileged pursuant to those proceedings. So you can say what you want in the courtroom. You can say what you want during a legislative procedure. If you make that exact same statement outside of that proceeding, outside of the courtroom, outside of the legislative proceeding, you would be liable. You could be sued for defamation. All right, so you have to be very careful. Next, a statement, the privilege is qualified if the statement is made by one corporate director to another corporate director and it relates to corporate business. If the statement is made by one corporate director to another corporate director and it relates to corporate business. Now, when you're on the board of directors for any company, you have a fiduciary responsibility towards that company, meaning your job is to make decisions in the best interest of the company. Now, what do you need to make decisions? You need information. So if something comes up that relates to the company, you have a duty to tell the other directors whether it turns out to be true or not. So your privilege is qualified because here's the caveat. It must relate to corporate business. If it has nothing to do with the corporation, you can be sued for making a defamatory statement. So if you said, Bob, the president of the company, was having an affair with the barista at the Starbucks on the corner, and he had embezzled company funds to take her on a trip. Someone told you this? Could you report it to the board? The answer would be yes. Why? Because he embezzled company's funds. It relates to the business. Now, if someone comes to tells you that Bob, the president of the club, is having an affair with the barista at Starbucks, and he's cheating on his wife, could you tell the board? The answer is no, because cheating on your wife doesn't have a direct impact on the business. Invasion of privacy, invasion of privacy. Invasion of privacy is 4 acts, not just one. The 4 acts that qualify as invasion of privacy begin with the use of a person's name, picture, or likeness for commercial purpose without permission. A name or picture is really obvious. If you use my name, that's my name. Everybody knows what that is. If you use my picture, you can tell it's me. Likeness is a little trickier because a likeness doesn't have to look like you, but it's something that represents you to the public. If the public sees it, they know who you're referring to. Intrusion on an individual's affairs or seclusion. Now, when we say affairs in this context, we mean your personal business. When we say seclusion, we mean literally your right to privacy in your home or on vacation or something like that. Right, so what does this mean? This means if you come to my house and you go through my desk drawer and you start looking at my documents, I can sue you for invasion of privacy. That's my personal business. It's not your business. If I'm having an affair on my wife and she hires you as a private investigator to follow me and take pictures of it, that would not be invasion of privacy. Why? Because my affairs are her affairs, right? And are you allowed to investigate yourself? The answer is yes. Because once again, when you get married, the two people are considered to be the same. Now, when you talk about seclusion, there's a slight caveat. In order for intrusion into someone's exclusion to be invasion of privacy, that person must have a reasonable expectation of privacy. A reasonable expectation of privacy. I know what you're thinking. What does that mean? Well, let's say you've got a backyard, you've got a beautiful pool in your backyard, and you've got a chase line in your backyard, and you like to sunbathe nude in your backyard. You put up this little chain fence that comes up to your waist, and everybody in your neighborhood, they just come and stand by the fence, and they look at you laying on your chase lounge. Could you sue them for invasion of privacy? The answer would be no. Why? Because of the fence you installed, you have no reasonable expectation of privacy. Now let's say, as opposed to putting this little waist-high chain link fence around your backyard, you put a 12-foot privacy fence. That means you got that tall fence and it's got the slats of wood in there that nobody can see through. And then right in front of the fence and right behind the fence, you planted 12-foot trees to make it impossible to see through it. And then some reporter gets a ladder and puts the ladder up against the tree and looks over the fence. That would be invasion of privacy. Why? Because of the steps you took to ensure that no one could see you while you were sunbathing. You had a reasonable expectation of privacy, right? When the person put the ladder up by the trees, they violated that reasonable expectation, right? So now you could sue them. The publication of information that places a person in a false light. Now, please do not confuse this with defamation, because the publication of information that places a person in a false light is not defamation. Why? The information can be true. The way it's presented creates the false light. With defamation, It's a false statement. With the publication of information that places a person in a false light, it's a true statement presented in such a way as to create the false light or the false impression. Let's say I ran for Senate and I won. You were my campaign manager. After my acceptance speech, I'm tired, I go home. You're young and you're really feeling yourself, so you go out to the club. You drink a bit, you do a couple of lines of coke, you're acting like a wild person, right? So they call the police and you get arrested. Now, when they take you to the station house, the precinct commander recognizes you as my campaign manager. So what does he do? He calls me up on the phone, 4 o'clock in the morning. He says, Senator Claire, your campaign manager's here. Tells me what you did and asks me what I want to do. I said, well, please just keep him in your office. I'll come and get him. I appreciate your discretion. I jump up out of bed. I get dressed quickly. I'm looking a little disheveled when I get to the precinct because I haven't shaved, didn't comb my hair. I know I don't have hair, right? My tie's a little crooked. And the precinct commander, releases you to my custody. As we're leaving the precinct, 5 prostitutes are released at the same time. A Daily News reporter happens to be standing outside and he takes a picture. They run in the paper and the picture says, Senator Claire leaves precinct with 5 prostitutes. Now here's the thing. Were the prostitutes and I leaving the precinct at the same time? The answer is yes. Were we together? The answer is no. Right? So it's the publication of true information that places a person in a false light. Right? That would be invasion of privacy. And finally, the public disclosure of private facts about an individual that an ordinary person would find objectionable. This is not sexy stuff. This is just your regular business stuff. Right? Last night, you weren't feeling well. You started throwing up and it came out green and red chunks. Would you want anybody to know that? I hope the answer is no. That would be enough. That would be objectionable. That would be invasion of privacy. Our last tort in this section is fraudulent misrepresentation. Fraud is the use of misrepresentation and deceit for personal gain. Another name for fraud is lying. Now, there are 4 elements that we have to establish to prove fraud. First is the misrepresentation of a material fact or condition with knowledge that it is false or reckless disregard for the truth. The misrepresentation of a material fact or condition with knowledge that it is false or reckless disregard for the truth. In other words, you know you're lying or you really don't care. Requirement number 2 is an intent to deceive. An intent to deceive. The reason you're telling the lie is because you want the other party to believe you. Requirement number 3 is justifiable reliance. Justifiable reliance is simply a reasonable basis for the plaintiff to believe the lie. And number 4 is damages. Damages must be suffered as a direct result of the reliance. Right? You have to prove all 4 elements in order to establish fraudulent misrepresentation. You happen to be a master mechanic and you come to my used car lot to buy a car. And I show you this 1972 Mustang and I tell you you're very, very lucky because despite the age of this car, it only has 25,000 miles on it, right? It was a show car. It was kept in a garage and hardly ever driven. when in fact the car has 500,000 miles on it. You look at the car, you open up the hood, you check out the engine, you start the car, you listen to the sound, you take it for a test drive, and then you come back to me, you say, this is a very nice car, I really like it, how much do you want for it? And I said, well, you know, a car that's sold in this condition, right, is worth about $100,000, but this is my wife's car lot, we're about to get a divorce, I'm really pissed at her, tell you what I'm going to do for you. I'm going to sell you this car for $10,000. Screw her. You buy the car, you get it back to your garage, and the engine breaks down from wear and tear. You decide that you want to sue me for fraudulent misrepresentation. Well, let's go back to the elements. Did I misrepresent a material fact or condition with knowledge that it was false or reckless disregard for the truth? The answer would have to be yes. I told you the car had 25,000 miles on it when in fact it had 500,000 miles on it. I knew it. Was there an intent to deceive? Once again, the answer has to be yes. I told you the lie because I wanted you to believe me, because I wanted you to buy the car. Was there justifiable reliance? Was there a reasonable basis for you to believe the lie? Well, in this case, the answer is probably no. You were a master mechanic. You inspected the car. You knew what you were looking at. So if you bought the car, it was for some reason other than the lie I told you. Now, number 4, were there damages? Probably. You paid $10,000 for the car that might be worth $500, but you could not sue me because you were not justified in believing me, right? You bought the car for whatever reason you wanted to buy it, but not because of what I said. Now, had you been a person who had never seen a car before, then you could have got your money back. Then you could have sued me because you'd have been justified in believing me because you perceived me as being an expert on cars. But because you are a master mechanic, you're the expert, I'm not, you're stuck with the car. Now, the last one is a causal connection, right? I saved this for last because a causal connection is a but-for test, right? And it can be kind of tricky to figure out, but it's still pretty good. And basically it's, but for the lie, would the harm have occurred? But for the lie, would the harm have occurred? That's your but-for test, right? And, you know, when you look at this, you say, well, but for the lie, would the person have bought the car, right? Had the person not bought the car, the person would have lost the money. If the answer is no, once again, you don't have a lawsuit. You cannot get out of the contract. If the answer is yes, you can. Now, key point, puffery, puffery, puffery is sales talk. Puffery is not fraud. Puffery, puffery, puffery is sales talk. Puffery is not fraud. You can distinguish sales talk from fraudulent misrepresentation based on the nature of what the salesperson says. If what they say is subjective, based on opinion, not fact, it's puffery, it's okay. If it's quantitative, if it's based on fact, not opinion, the false statement would be misrepresentation. If I tell you this is the most beautiful car, the sexiest car, the most luxurious car, what does that mean? It means I think it's the most beautiful car. I think it's the sexiest car. I think it's the most luxurious car. Is it? Not necessarily. If I tell you the car has 20,000 miles on it, when it has 200,000 miles on it, that's quantitative. It is or it isn't. That would be fraudulent misrepresentation.